So, friends, from soldiers standing up and speaking out, announcing that they will not obey unlawful orders, to the Trump administration continuing to murder people in international waters, to Donald Trump saying that he can deploy soldiers to U.S. cities and even the courts can't stop him. America is in a very tough spot. Some might even say our nation is in peril. So friends, I sat down once again with law professor, military law expert, and retired Army JAG, Dan Maurer, for an update on these and other military-related issues. I hope you enjoy this conversation with Professor Dan Maurer. Friends, welcome back. We've got law professor Dan Maurer with us once again, military law expert, retired Army Lieutenant Colonel, JAG officer, law of war expert, law professor teaching at Ohio Northern University's Claude Pettit College of Law. He is becoming a regular guest with us here on Substack, and I turn to him every time I see some shocking new military development, and I look forward to him kind of helping explain and unravel for us what's going on. So Dan, thanks for jumping back on with us today.
Good to be here, Glenn. Thanks, and happy Halloween to everybody.
Happy Halloween. It is a particularly frightening Halloween this year. All right, so the first thing I want to talk about is a piece you just put up on Substack titled Disobeying Military Orders, and I have to admit I was somewhat encouraged when I saw that there were 2 Illinois National Guard members who felt compelled to speak out publicly and announce that they would not obey unlawful orders to deploy to the streets of Chicago. So kind of tell us a little bit about the piece you wrote, what they said, and then we'll kind of talk about what you think it all means.
Right. Well, again, thanks for having me. These 2 Illinois National Guard members, one a non-commissioned officer, a sergeant, and one a captain, are noteworthy for a couple of reasons. The first is they're in leadership positions. An NCO is going to be leading a team, depends on how much rank she has and what kind of unit she's in, but she's going to be in charge of some folks. The captain is either going to be in a formal leadership position or by virtue of being an officer, an informal expected leader. People will be looking to that person for guidance and direction. So for these 2 individuals to come forward and say something as direct as I will not obey an order to deploy is noteworthy for the kind of influence it might have over their subordinates. Now, you mentioned that you were initially encouraged by that. I was too. But there are some concerns with it. One, for them personally, their own criminal liability. We'll talk about that. And 2, the fact that it could have an adverse negative impact, one that goes beyond what they intended, and one that could be detrimental to a healthier kind of relationship between the National Guard and the federal government, between the National Guard and the citizens of Chicago. So the first thing I would say is an order to deploy, an order to do anything from a military superior, whether that's in uniform or a president or the Secretary of Defense, is presumed to be lawful. It's very hard to overcome that presumption, and that makes sense because you put soldiers in harm's way, and you tell them to continue to be in harm's way or go risk your life. That's contrary to your instinct for self-preservation, and you don't want people second-guessing that. You need them to do what they're told to do when they're told to do it, mostly unquestioning. That's the nature of military orders, ultimately for combat. So there's a presumption of legality. It can be overcome and you can disobey an order without consequence, without criminal consequence, because that's a crime, disobeying an order, if the order is patently unlawful. That is, on its face, an objective person would know that that order is a crime, like taking a detainee or a prisoner of war and murdering them, executing them. That would be something a normal person, in uniform or not, would know is a crime and therefore should not be followed. In order to deploy troops is less clear. It's not as patently unlawful because if nothing else, that issue is being litigated right now in the courts in 3 different states, California, Oregon, and Illinois. And both sides have arguments. One side has good arguments, the other side not so good arguments, but it is not completely obvious which side is going to win. Whether Trump has the authority to deploy the National Guard into Chicago or Portland or continue in LA, that is still kind of up in the air. Some of the lower courts have said, well, there are some concerns here, there are some constraints, and those orders have been temporarily restrained. But ultimately, the Supreme Court will weigh in and will determine whether or not the president can use the authorities that he says he has to do what he wants to do. But until that point, it's kind of up in the air and therefore not patently unlawful. So to say, I'm not going to deploy and not follow that order does not seem to give that captain or that sergeant a legal defense. They would still be liable for what they did. That doesn't mean it's wrong. Doesn't mean that they shouldn't have done that. It just means that they should know the risk. And maybe they did. Maybe they were well aware of the criminal liability that they're exposed to. And they decided to do that anyway, to say that anyway. And there's a phrase that is often heard in the military that you disobey unlawful, unethical, or immoral orders. Well, disobeying an unlawful order is certainly expected. But you can have an order that's lawful and still immoral. An order that's lawful and still unethical, according to your own personal belief system. You have no legal defense if you were to disobey based on your own sense of justice, your own sense of morality. But that doesn't mean you shouldn't do it. It doesn't mean you shouldn't disobey. You might feel like you have professional grounds, moral grounds to disobey, and you're willing to risk the criminal consequences. And maybe that is the case with these 2 individuals. It's a little bit like a case at the early stages of the Iraq War in 2003. There was a lieutenant, an active duty lieutenant in Washington State out of Fort Lewis, who said, I don't think President Bush has a lawful authority to invade Iraq. I think it violates international law. Therefore, I'm not going to participate in this war crime of deploying. And he was court-martialed for it. And ultimately, what the courts said, and I don't believe he faced any prison time for this. He was removed from the military, certainly. But the argument was, you, the lieutenant, don't have the legal authority to question a decision to deploy troops in an international conflict. You might have the ability to say a particular order to attack a particular place, a particular person, a particular target might be unlawful, and you could object then. But the overarching idea of the U.S. invading another country, you don't have the ability to decide whether that's lawful or unlawful. You don't have enough information. You're not a lawyer, et cetera, et cetera, et cetera. So for these individuals, this captain and this NCO, to say you don't have the authority to do this is like that. In fact, I'm not even sure that what they're saying is that it's an unlawful order. That what they're really objecting to is just the idea of National Guard troops operating in their cities against their fellow citizens or any people there, whether citizen or not. They object on moral grounds. They object on practical grounds. They object on political grounds, not legal grounds. And that's a big difference. And an interesting point here is that both of them are running for office. Now, of course, that may very well be the reason why they spoke out when they spoke out. One is running for state legislature and one is running for Congress. I have very little reason to doubt that that influenced their decision to speak up.
So, okay, a couple of things. First of all, I think everybody probably at this point wants to take Dan Maurer's class because of the way he lays things out. And listen, I'm an officer of the court, so I have to be honest about my praise. And this is why I'm a paid subscriber to Dan's Substack, and I hope you all will consider doing the same because this is such important information when we may very well be on the brink of war not only with Venezuela, but internally. I mean, that's not hyperbole, unfortunately. But now let me drill down on a little bit of what you said. I'm going to be Dan's student here, see maybe if I can persuade him a little bit. And I'm going to quote from his own article because he quotes what the captain whose name and I don't know if you put the name in your piece, but they've given public interviews on mainstream media, and the captain's name is Blaha, Captain Blaha, and the staff sergeant's name is Palachek. And so here's what the captain said, quote, I signed up to defend the American people and protect the Constitution. When we have somebody in power who's actively dismantling our rights, free speech, due process, freedom of the press, it's really hard to be a soldier right now. We're not trained to assist ICE and help them just be violent in our communities. It's shameful. And what Staff Sergeant Palachek said is, quote, I would definitely say no when she was asked, would you obey an order to deploy to the streets of Chicago? I would definitely say no. I'm not going to go against my community members, my family, and my culture. I believe this is the time to be on the right side of history. When I read that, I was almost rooting for her to add, I'm not going to go against the Constitution, but she didn't include that. So, Dan, you bring up so many important nuances. First of all, can these soldiers be disciplined for just saying these things, answering hypothetical questions, assuming that what they're articulating is, I won't obey unlawful orders? If that, let's give them the benefit of the doubt and say we can infer that that's what they were communicating. Can they be disciplined for just saying it?
So this is a very, very difficult question to answer. Great student question. Um, so let's, to your point, let's infer that they are intending to convey the message, I intend to disobey an unlawful order in the future tense. I will disobey an unlawful order, and I consider deploying into Chicago to be an unlawful order. Let's assume that that's what they meant. You have a right to disobey an unlawful order. You may have a duty to disobey an unlawful order as a professional soldier. But the way in which it's being conveyed, right, the context of it matters. And as a former prosecutor, context does matter. And the circumstances matter. And the way in which they're conveying this is a message that's anti-Trump. That I think there's no doubt about that. And I think some of the words that the captain used certainly suggest that. And that's fine to have a political opinion. And the concern is when a service member who expresses a political opinion does so as a soldier. Some of those rights that are protected for everybody else dim. They soften a bit. Soldiers do have a First Amendment free speech right and a First Amendment free assembly right. There's no doubt of that. However, the Supreme Court has long held that right can be constrained in many circumstances. So a soldier can't go to a political rally if they're in uniform. They can go to a political rally. They can express their opinion in an op-ed. They can vote. But they can't go to a rally in uniform because that suggests that the military has a partisan stance, or they're expressing an implied partisan stance of the military. And we want to make sure that the military remains apolitical, nonpartisan. Moreover, speech can be constrained in content. So there's an article of the UCMJ, the Uniform Code of Military Justice, that prohibits officers, not NCOs, not junior soldiers, but officers, from contemptuous speech or using contemptuous words against certain people. President, Secretary of Defense, Secretary of Homeland Security, the Vice President, Congress as a whole, not individual members, but Congress as a whole, the legislature or governor of the state in which that person happens to be residing in at the time. Contemptuous words against those individuals or bodies is a crime. Doesn't really define, however, what contemptuous words mean. There have only been 2 prosecutions that I'm aware of, successful convictions under Article 88 of the UCMJ. One was in the 1960s with the lieutenant who protested on the streets of the Vietnam War and wore a billboard-type protest sign that basically said, basically called Lyndon Johnson a fascist and said nasty things about the Vietnam War. And he was charged and convicted of using contemptuous words. More recently, a Marine lieutenant colonel, in the wake of the pullout from Afghanistan, went online using his social media and posted a video of him railing against the active duty uniformed leadership, blaming them for the resulting chaos and the deaths associated with the withdrawal from Afghanistan. He was also charged. Ironically, I don't believe he was convicted by court-martial. I think it was downgraded to essentially non-judicial punishment. The point is, he's not in jail. In fact, he is now a special assistant to the Secretary of Defense as a civilian. So that's something. So words matter. What they say matters, and how it's used matter. It could be interpreted, the captain's statements. If you had a vengeful, aggressive administration, could interpret those words as contempt. Now, however, he is not on active duty. UCMJ applies to active duty forces and National Guard when they are on active duty. Illinois, however, has its own Uniform Code of Military Justice. So when he is in his state capacity or as a citizen of Illinois and he says things like this, he may very well be violating the Illinois UCMJ. It has a very similar provision to the federal one. Now, the likelihood of him being prosecuted by Illinois, where the governor of Illinois is the commander-in-chief, is very unlikely. He's aligned with the governor's view on the Trump deployment into Chicago. So even if he were to be prosecuted by the military, National Guard, it's very possible that he could get a pardon from the governor of Illinois for doing or saying what he did. So the point is, the content of the speech very well exposes them to potential discipline, potential punishment. And the discipline in the military can come in many, many forms. It can come in on the far end of the spectrum of severity, court-martial, which is a federal criminal trial. You can go to prison for a very long time for a conviction by court-martial. On the far other end would be more administrative personnel type decisions, like employment decisions, where you get busted in rank, down in rank, and therefore loss of pay. That might be temporary or might be permanent. You could be separated from the service, essentially fired from the military. So an employment type consequence. But all of those are very real adverse consequences that they face when they speak out, even if they're speaking truth. Truth is not a defense. Accuracy is not a defense to the contemptuous words article. And there are lots of other articles, and we don't have time to go into them, but there are other even more generic and widely applicable articles of the UCMJ that they're exposed to, whether they say anything or not.
So, I mean, all of the nuances and twists and turns are fascinating, and make it clear that these aren't really questions that can be definitively answered in the abstract as hypotheticals. And as an added layer, you get to the motivation that one command or another, state command, federal command, might have, what their interests, their motivations might be in wanting to court-martial or decline to court-martial somebody or pardon somebody. So that is all fascinating. So I want to finish that topic with this question before we turn to the next topic, which is, I think we are up to 60 or 61 human beings that have been killed in international waters in a total of 14 boat strikes. I want to turn to that in a minute, but let's finish out this one with this. And it's, again, going to be a bit of a hypothetical. I think the state of legal play in Chicago in the courts is that the trial court judge issued a temporary restraining order prohibiting Trump from deploying soldiers to the streets. The Seventh Circuit Court of Appeals affirmed that in a unanimous three-judge panel opinion, including a Trump-appointed judge. Given that the state of the law right now prohibits the military from being deployed, would that give soldiers cover if they said, I'm refusing to deploy. I'm going to violate that order because the courts right now are prohibiting it?
That's a hard one. I'm not sure because, frankly, we really don't have a historical precedent for this, other than a case from 1827 called Martin v. Mott, which is getting a lot of airtime in these cases, involving slightly different reasons. But the facts are essentially a New York National Guardman, a New York militiaman, essentially refused to deploy to fight the War of 1812. And years later, his case comes to sue the civil system based on back pay and various other issues. And the bottom line result of that case was a statement by the court that basically said an individual soldier doesn't have the authority, the position, kind of call it the standing, to question when the commander in chief orders them to deploy in the broadest sense. Again, not talking about a tactical decision to, take out that particular village with a bomb, but to just deploy in the first place. You don't really have the position to even question that. You just do it, whether a court says it's lawful or not. Again, all these court decisions are still they're still preliminary decisions. The merits of these cases, whether or not the president has the authority under 10 U.S.C. 12406 or his presidential protective power, whatever that is those are still open questions. The immediate temporary restraining orders are in place and courts have approved them, but they're under appeal. So if you're a service member like this captain, who then, if Trump were to say, I'm ignoring the Seventh Circuit, I'm going to deploy, he could make an argument, I think, the captain could make an argument that the state of the law is such that it's pretty clear that right now we can't deploy. We might be able to be forced to deploy later on, but right now we can't. He might make an argument like that. I don't know how successful it would be. Again, because we're in this weird gray space of timing where it's in this flux of litigation in three different jurisdictions involving two different courts of appeal, all involving the same basic idea, same basic law, and the Supreme Court hasn't weighed in on it yet.
Yeah. Great discussion of that topic. Let's switch to killing human beings in international waters. You and I have discussed this. You have been pretty clear on, I think, your conclusion that there is no lawful authority for our military or Donald Trump to be ordering our military to kill people in international waters. And with respect to the 14 boat strikes that have killed 60 or 61 human beings in international waters, we talked previously, Dan, and I think we are both bullish on the military, the honor, the ethics, the loyalty to the Constitution, in keeping with the oath they took. We are believers, given our military service, you far longer than me, that the military is going to hold. And are you feeling any differently now that these lawless murders, I will, as a career homicide prosecutor, I will call them what they appear to be, murders of human beings in international waters, have been ratcheting up, becoming almost routine? Does that give you a different view of whether the military is holding strong, capitulating somewhere in between, or can you draw no conclusion about what's going on inside the military?
Well, I would, I'd love to have an answer of it's slowing down and stopping, and military members are rejecting this premise that the Trump administration has about the nature of these these criminals being combatants. But unfortunately, to your word, it is ratcheting it up. It seems it becoming more frequent, and that is alarming to me. And as we have discussed, there are many reasons why I think it's unlawful, both under domestic law and international law. And my worry has always been, well, where are the JAGs? Where are the lawyers giving the advice? Maybe they are there giving the advice, and they're saying it's unlawful. But JAGs don't make decisions. They don't make command decisions. They don't issue the orders. All they can do is be experts in the law and be in the room when those plans are being made, and have the moral courage and the professional duty to stand up and say, this is unlawful. You shouldn't do it. And here are the consequences if you do. But as I said before, because it keeps happening, I am concerned that the JAGs simply are not there. They're not giving the advice because they're not in the room where it happens. They're not in the room when the order is being made, when the planning is being discussed. They're not present. Now, we have heard that the Southcom command, the 4-star admiral, I think, essentially retired well before he could have retired. In terms of after his 4-year term of service as the combatant commander would have expired, he was in the job for a year and he retired. And the word on the street is that he did object. He was pushing back on these strikes based on not moral grounds, maybe there were too, but definitely on legal grounds. That tells me that he was getting advice from his SJA, the Staff Judge Advocate, and he's providing that advice to his chain of command. I mean, he only reports to the SecDef and the president, and whatever civilian the president wants to put in between them. Frankly, that may very well be Stephen Miller, for all we know. And when that advice was being rejected, he evidently, I'm speculating, decided it's time to leave. Now, I don't know if this is the reason why he decided to leave. Maybe there's a personal reason, maybe, who knows. But if it comes out that he is retiring before he could because of this, then he's retiring in protest. And I would love to hear that. I think he has a duty. Not every Civ Mill scholar believes this, but I think he has a duty as a professional with that degree of experience to explain to the public why he chose to do it this way. Let the public make up their own mind about whether it was right for him to decide to resign as opposed to just follow the order. But I think he has a duty to explain it to the public. After all, his duty is to the public through the Constitution, not to the Secretary of Defense, not to the President of the United States. So it's encouraging in some sense that if this is true, that he resigned for this reason. But that doesn't mean the lawyers are going to continue to be listened to. Again, even if they are in the room. So we were talking earlier about recent congressional testimony by members of the Department of Defense who were there to talk to various committees about these strikes, particularly about the legality of the strikes. Now, up to this point, no legal opinion by Department of Justice has been released that purportedly exists, that it does explain Trump's legal rationale for doing this, but it's not been made public. That in and of itself is unusual and disturbing. Second, the Department of Defense lawyers have gone to the Hill before and talked to various committees informally or with individual members, given them top secret briefings on this, and have been questioned by those members about the legality. And they have not received, according to public reporting, satisfactory answers. Then you have this episode where members of the DoD are talking to Congress, and the idea being, give us your best legal argument here. The lawyers were told to go home. The lawyers were prevented from being there in the room, not by Congress, but by the DoD. Why does one do that? I can't think of any plausible, legitimately good faith reason to deny the lawyers the ability to testify. Those lawyers have a professional duty under their codes of responsibility in their respective jurisdictions to be candid with tribunals, to include Congress when they're testifying under oath. If Congress says, do you have a legal objection to this mission? or have you raised legal concerns to your commanders? They have a they have a legal duty to say that, but they can only say it if they're in the room.
And you just segued us right into the third topic, and you've covered most of the terrain, but let me just put an exclamation point on what you said. So the DOD briefed, I believe, the House Armed Services Committee on what they thought, the committee members thought they were going to get the administration's justification, the lawful reasons that they claim they get to murder people, kill people in international waters. And not only did they not get a satisfactory legal explanation, as Dan just mentioned, they told the lawyers to leave and not participate in the briefing of the House Armed Service Committee members. And that inspired bipartisan, I think, more than concern. It was outrage. And, I saw an interview with Representative Seth Moulton, who was outraged. And there is a representative from Ohio, a Republican representative, Mike Turner. So I didn't want to exaggerate his words. I listened to his interview and he said, quote, "There were not very good answers regarding what was occurring in connection with these boat strikes. They wanted to know what the standard is, what standard is being employed to strike these boats, and they were provided no satisfactory answers. He said, this is a Republican representative, the lawyers were supposed to be in the room and they were not. There has not been a satisfactory legal justification. When Republican members of Congress are talking like that, I think I am ready to reach the reasonable inference, which is what we do all day long in criminal cases, that the reason they told those lawyers to get out of here is because they don't have a satisfactory legal justification for killing human beings in international waters. And if there's anything else you wanted to add to that scenario.
No, 100% agree. You know, I liken a lot of this to being a parent with kids, young kids or teenagers, and a parent is concerned with the kid's behavior, and you say, I want to know what you were thinking, or I want to know what happened, and they refuse to talk. What does that signal? Right? That signals that they know they did something wrong, and they don't want to get into more trouble. Of course, we know that when you obscure or hide or lie, that's sometimes worse than the actual crime. Now, of course, in this instance, when real people are really dying, the lying is not worse. It makes the overall event worse. The lying is not worse than the actual murders happening. And I agree with you. I think they are murders.
So let's just finish with this. And I just want to throw this out and ask your thoughts, because I think this, frankly, can play into soldiers' decisions whether, you know, obeying an order to deploy to the streets of Chicago is lawful, patently unlawful, or somewhere in between. It can, I think, factor into what's going on in international waters, these murders that are being committed. Donald Trump recently said, in recent days, he said that he could deploy the military to U.S. cities and not even the courts could stop him. Now, we can probably agree that as a matter of law, he's wrong. The courts would have the authority under the proper circumstances, the proper facts and law to order him to stop. But as a practical matter, I think we have to go back to, I think, what Justice Sandra Day O'Connor first said. I don't think it was Justice Ginsburg. I think it was Justice O'Connor who first said, we, the Supreme Court, don't have an army. We don't have a law enforcement agency to force the executive branch to comply with our orders. So Donald Trump may be right. In a practical sense, the Supreme Court can't stop him. That is, if he is willing to completely disregard our sort of construct of governance in the United States. But what, what does that conjure up for you when you hear the president slash commander in chief make a statement like that?
fear, um, disgust, anger, um, all the things that you signed up to do when you joined the military, the things you swore to when you became a lawyer, um, supporting, defending the Constitution of the United States in whatever capacity you can, because that's the charter of how our government works and how our society functions. And it can only function if the members of our society that we've entrusted with certain duties and responsibilities act in good faith, honestly, in the public interest. And I'm quoting that Martin v. Mott case from 1827 when I say that. That was the expectation from the founding generation, that the people selected to be our leaders would act that way. And the image that conjures up when you quote Trump like that, um, leaders in democracies don't use those words. They don't. That's tyrannical. That's dictatorial. That's authoritarian. Pick all the bad words you want to label. That's not what a leader, a democratically elected leader in a separate federalized system governed by the rule of law, says. Even if it's factually practically true that the court can't do anything, you don't say that, because you know that you, as the chief executive, in charge of the executive branch, are going to ensure that when you are faithfully executing the law according to your constitutional duty, you are following the law. And that's what the Supreme Court says is the law. When they're interpreting the Constitution, the buck stops with them, not with the president. Buck stops with the Supreme Court. And I'll conclude with this historical analogy. It worked well in 1952 in the Youngstown case, where Truman tried to nationalize the steel industry because he wanted to avert a catastrophic steel strike that would have impacted the war effort in Korea and the national economy. And when he did try to nationalize it, the owners of the steel mills went to court. It got fast-tracked to the Supreme Court. The Supreme Court said, no, you do not have Article 2 power to do this. You have no authority from Congress to do this. Therefore, you can't do this. And in response, Truman griped, he grumbled, he cursed, but he obeyed. And he rescinded the order to nationalize the steel industry. He backed down because that's what the Supreme Court said. He didn't threaten them. He didn't say, well, try and make me. He did what a law-abiding president does. He said what a law-abiding president says. And that's not what we're seeing today.
And friends, here's a little behind-the-scenes glimpse. At this point in my conversation with Dan, my video dropped out. But Dan, ever the pro, finished up the video for me. So here is Dan finishing things up.
Meanwhile, I guess I'll pitch my own Substack. If you're still with me, you can find me at Politics by Other Means. I'm on LinkedIn quite a bit. I encourage you to hang out with me where you can. I try to post every couple days on LinkedIn and on my Substack. I talk a lot about these national security law issues. I try to talk about more generalized criminal law issues when I can. But obviously, there's a lot going on in the national security space that keeps a lot of my attention fixated on that.